We'll hear argument next in Case 12-761, POM Wonderful versus the Coca-Cola Company.
And so do you concede that a Lanham Act plaintiff could not challenge aspects of a food label that the FDA said is required?
Well, Justice Kennedy.
I know that's not this case.
Thank you. Let me just say, not only is that not this case, because the FDA has never examined
I want your answer to the question. Yeah.
My answer to the question would be, under Wyeth, under this Court's decision in Wyeth, the FDCA and the FDA's regulations interpreting and applying it supply a floor and not a ceiling, and the FDA would have no authority. If the FDA said, this label is fine, and you are required to use this label, the question would be, does it have the statutory authority to essentially create an immunity from enforcement of another federal statute that protects a different purpose and a different class of victims?
I think
the answer would be no. I hope I'd answer.
This question, I think, was different. He said, suppose that it said, you're required to use this label and only this label. Then you would acknowledge that there is an impossibility issue. Is that right?
Yes, unless, as in Wyeth, there was, in fact, some possibility to change the label. But if, and I apologize if I didn't understand the question, if the FDA said, counterfactually, we've examined this label, you are not only permitted to use it, but you are required to use it, and unlike what we do with respect to pharmaceuticals, you are not allowed to make any changes. In that instance, there would be an irreconcilable conflict, and a court would have to decide which of two opposite-facing canons of construction to give primacy to. But that would be impossibility.